Hello, I'm Traudy Grande. I'm a certified financial planner and partner of Grande Financial Services, author of Ophthalmology Times Money Matters column, which offers you the Ophthalmology Times e-magazine resource page. This video is the second part of a two-part presentation entitled Estate Planning Basics for Everyone, Helping Protect Yourself and Your Legacy. In this video, I will talk about the roles and responsibilities of the people you name to serve in the documents we covered in video number 1, as well as how an account or an asset is titled. I will also discuss what types of assets have beneficiary designations and why it's important to ensure that those you name on those designations are consistent with your overall estate strategy. Each of your estate planning documents will require that you name someone to help you either during your lifetime or at death. Let's take a look at those roles. The key people you will need to name include an executor or executrix, a guardian, an agent for a durable power of attorney, a healthcare agent, and a trustee. One of the most important decisions you will make is picking the person or people who will be in charge of your assets and legally obligated to act in your interest. The task of each of these is slightly different. It is recommended to name more than one alternate for each role, but you may also name two persons to act together, such as co-trustees or co-executors. An executor is someone who carries out the directions in your will. Sometimes you'll hear the term personal representative for this role, and if you leave no will and your estate is managed by the probate court, this role is sometimes referred to as administrator. This person will be responsible for collecting the assets of the estate, protecting the estate property, preparing an inventory of the property, paying valid claims against the estate, including taxes, representing the estate in claims against others, and distributing the estate property to the beneficiaries. It's important to know that the executor only controls property or assets that are subject to probate. If you have a minor child, you need to name a guardian to raise your child in the event both parents die before your child becomes an adult. While the likelihood of this is actually happening is slim, the consequences of not naming a guardian are great. If you don't name a guardian, a judge will decide who will raise your child without knowing who you actually wanted. This is an important role to revisit over time. For example, early in life you may name your parent or grandparent as guardian of your toddler, but as all of you grow older and your toddler becomes a teenager, perhaps it's wiser to name one of your siblings who is closer in age to you rather than an aging parent or grandparent to care for the teenager or young adult. In the power of attorney, you give authorization to a certain person or people to make decisions on your behalf. This person is known as an agent. Realize that this document and person who have control only during your lifetime. The power terminates at your death when your will or trust instructions become effective. This is an important document to avoid court intervention at a very stressful time. Imagine if you didn't have this document and you're severely injured. On top of your health concerns, your family may need to deal with court appearances to be able to manage your finances or make certain financial decisions on your behalf. Deciding who you will name as your healthcare agent is one of the more difficult and important decisions you will make when planning for the future. Your healthcare agent receives a durable power of attorney for healthcare from you, which gives your agent the power to make medical decisions for you if you are incapacitated or otherwise unable to make medical decisions for yourself. Your agent will not be able to override any healthcare preferences you set out in a living will, but will have complete authority to make any other medical decisions. If you have strong feelings about your healthcare, this is the place to express them as specifically as you are able. If you decide to create a revocable living trust, you need to name a trustee or co-trustees to manage your assets. Realize that the trustee will control only those assets that are in the trust, but he or she will manage the property as directed in your trust. So if your trust directs that the trustee ensure all bills are paid, all debts owed to you are collected, and then all assets are distributed in a timely fashion, the trust will end fairly soon after your death. On the other hand, you may want your trust to endure for some years or decades. This allows you to control how assets are managed and distributed over time. Perhaps you have a spendthrift or minor child who you want to provide income for over time. In this case, the trustee will serve for the time period you direct in your trust. Earlier, I talked about the importance of retitling assets, especially if you establish a trust. Let's take a closer look at both account titling and beneficiary designations in our final section. At your death, assets may take different routes. You can liken these topics to off-ramps on an interstate highway. Depending on how you title assets or designate beneficiaries, assets can go different directions at your death. For example, assets titled in your name alone will be governed by your will and go through probate. Assets in a trust or held in joint tenancy will bypass probate. Again, neither direction is necessarily right or wrong, but one or another may be more suitable for you. You should discuss these possibilities with your attorney when you meet. Let's take a closer look at how titling matters, starting with assets in your individual name. Your executor will control these assets and he or she will follow the directions in your will. They will be distributed at the conclusion of the probate process. Assets in your revocable trust are controlled by the trustee or successor trustee. The trust document provides instructions and they will be distributed or managed according to the terms in your trust. A beneficiary designation acts a bit differently. This is a contract between you and the financial institution, and the terms of that contract trump everything else, even what your will or trust instructs. Your beneficiary will file a claim and the financial institution will distribute the assets. No probate, no governance by a will or trust instructions. Finally, when you title an account jointly with someone, such as a son or daughter, at your death, the son or daughter owns that asset. That outcome may be a mistake. Perhaps your intent was that the son or daughter would divide the value of that asset among his or her siblings. That may or may not happen, and even if it does, it could have gift tax consequences for that child. Or perhaps you become incapacitated and the other owner wants or needs to move the account. The financial institution may require the signatures of both owners to do so. Discuss these implications with your attorney before deciding whether joint tenancy is the best way to achieve your goals. Now let's talk about assets that have beneficiary designations. What kinds of assets are we talking about? The ones that frequently come to mind are life insurance policies, annuities, IRAs, or other retirement plans, and transfer and death accounts. But also keep in mind other benefit plans, perhaps at work, where you have completed a beneficiary designation form. Accounts such as stock option or stock purchase plans. Most importantly, be mindful of all of the beneficiary designations as your family situation changes, and be sure to update them appropriately. Every 3 to 5 years, or whenever your circumstances change, be sure to review your beneficiary designations so they remain consistent with your wishes and objectives. Now, let me summarize. Every adult should have a will, power of attorney, healthcare power of attorney, and a living will. Choose the right people to carry out your estate plan, and it is extremely important to coordinate your documents, asset titling, and beneficiary designations. Regularly review your estate documents, titling, and beneficiary designations to update for life events and changes in your family. This concludes our 2-part Estate Planning Basics for Everyone videos. Please feel free to contact us with any questions that you may have in this area or for additional information. Thank you.
To learn more, call 1-800-722-1258.